Hi there, and welcome to sydneydrinkdriving.com.au. Hi guys, Josh Boorman here from sydneydrinkdriving.com.au. Just another update today on a matter that I had out at Fairfield Local Court this morning. This matter was quite a serious matter. He was a repeat offender. It was his second drink driving charge within the space of 4 years, and it was a charge of Middle Range PCA. The blood alcohol reading was 0.099, but obviously the fact that it was the second in the last 5 years increases the penalties and sentences and is dealt with far more seriously by the court system. Basically, I was able to present a number of submissions to the court. I was also able to tender certain documents. My client admitted that he did have a history of alcohol abuse, and we got him along to see a psychologist to get some professional treatment for that and a number of other emotional issues that he has been going through. So, in other words, I was able to tell the court that he was able to jump on the front foot, take proactive action in order to try and treat the root cause of his problem that has led to his offending behaviour. And certainly we tendered a report from his psychologist which said that he had been doing a number of sessions, that he'd been responding well to those sessions, and that he is intent on continuing with his treatment into the future. In addition to that, my client went along and did the traffic offender program. Now, my client was 45 years of age, but because he did have such a poor traffic history, it was important that he go along and complete the fully approved 6-week traffic offender program in order to show the court that he is making an attempt to re-educate himself about how alcohol affects the body and also general driver safety. The court took these submissions very well. I was also able to explain to the court how the circumstances surrounding my client's incident, the fact that there were no significant aggravating features involved. My client had travelled for the weekend to go out to visit friends in a remote town out in regional New South Wales. He was pulled over for the purpose of a random breath test. He was the sole occupant of the vehicle. He had only gotten into the car when he was at this town to drive late at night to go looking for some food. Now, whilst that, and there is no excuse for getting into the car whilst you are over the limit, these are all factors which certainly show that there was a reduced amount of danger to other people on the road. It was late at night and there was no other drivers on the road. So this was obviously taken into account by the court just to show that there were no aggravating features involved in this drink drive incident. It was, as one would say, a relatively standard PCA type of offence. But of course he did have that second one there, and the court can't turn a blind eye to a repeat offender. A number of other subjective issues were raised before the magistrate today, and they involve the fact that my client has a very important need to maintain a driver's licence due to his employment. He is required to travel to various locations in and around Sydney for the purpose of completing his job. Now, without a driver's licence for an extended period of time, we were able to get a report from his employer saying that he'd simply lose his job and be terminated. Whilst his employer was going to be flexible and patient in the short term, this is certainly a submission that we were able to push towards the magistrate to show that if he could get his licence back after the minimum disqualification period, then he would be able to maintain his employment and continue bringing in an income for he and his family. So these are all issues in relation to subjective features and objective features surrounding this offence that appeared in the Fairfield Local Court today. At the end of the day, we got a very good result for my client. The incident occurred a couple of months ago, so he's already been off the road for 2 months, but we were able to persuade the magistrate to give my client the minimum disqualification of 12 months. Now that's the minimum disqualification for a second or subsequent mid-range drink driving offence within the last 5 years. So he got 12 months disqualification, he got a reduced fine of $450, and I also got the magistrate to make an order that he backdate the disqualification period to the time of the offence, or alternatively the time that he already has served off the road, suspended since the time of the offence, has been taken into account as time already served off the disqualification period. The other very important order that we were able to get the magistrate to make was that my client was willing and able to take part in the alcohol interlock program, and this was something that I pushed hard and it was successfully granted by the magistrate. Basically what this means is that he is able to serve a reduced disqualification period of 6 months instead of the minimum 12 months. But the catch is that my client now, after that 6-month disqualification period, has to have an alcohol interlock device in his car for a period of 2 years once he begins driving again. Certainly a person with alcohol issues in the past, he was a prime candidate to enter into this alcohol interlock program. The good thing with this and for my client is that in about 4 months from today, approximately 4 months from today, he can get his licence back, a special alcohol interlock licence. He can continue to drive and continue to be able to perform his duties for his work. So it will have minimum disruption to his ability to earn an income. However, in saying that, it will also put him at a certain level of deterrence and penalty by having to fork out money to enter into the alcohol interlock program, and also it will certainly put him on guard that he can't even get into a car with having any alcohol in his system. So at the end of the day, my client was extremely happy with the result we got. He understood that he would lose his licence being a repeat offender for a period of time. He had no emergent reasons for getting into the car, but what we were doing today, we were seeking to get some sort of lenience from the court, and I believe that's exactly what we did. He was very happy with the overall outcome. So guys, if you have a drink driving offence or an alcohol related traffic offence, we deal exclusively in these types of matters at all local courts in and around Sydney. Certainly if you have been charged, feel free to give me a call at the office on 02 9283 8622, or alternatively you may have already seen our website, that's sydneydrinkdriving.com.au. Now you can go to our webpage and there's a raft of information in relation to penalties, laws, traffic offender programs, blog posts, a heap of information surrounding criminal drink driving offences in New South Wales. But like I said, you can get on the phone, give me a call. I'm happy to have a free first telephone consultation with you just to assess where you're at with your matter, give you a bit of an idea of what the process is and what the court system expects of offenders or defenders. Like I said, our number is 02 9283 8622, or visit our website. You can even drop me a message through the website at sydneydrinkdriving.com.au. Thanks guys.